Hello, how are you today? My name is Cole Watson. We get this question all the time. A lot of people are confused about what estate planning is. It's a really funky word, a funky phrase, really confusing too, unless you're an attorney or a financial planner or a CPA or something. So I'd say for the everyday Texan that I love to represent and love to serve, estate planning doesn't make any sense, but they hear about it. And so this video is just an opportunity to introduce not only myself, but then what this concept is. And if there's any way that we can help you with your estate plan, let us know. Okay, so a little bit about myself. My name is Cole Watson, the founder of the Watson Law Firm. We have a great team here. We focus on estate planning and real estate issues. Inevitably, things like probate and business come along as well. This is my beautiful wife, Kelsey, our two boys, Everett and Topher, and we just welcomed our newest member, Margaret, as well. Okay, so estate planning is what happens to your stuff after you die. It's a really tough subject. It's really complicated to think through. Our own mortality, we are going to die. That is not a comfortable feeling. It causes a lot of anxiety in us, and more times than not, we'd rather just ignore it, right? We don't want to think about it at all, especially a younger population of people who absolutely need estate plans in place, believe they don't die, right? They believe they're going to live forever. And so until you're actually faced with your own mortality, this concept of planning for your death, I think, seems very foreign. So the idea here is that, of course, you die. That should go without saying. But then you have all this stuff that has to get taken care of. You got the not only the personal property, maybe you got a car, a house, bank accounts, life insurance proceeds, retirement accounts, all this stuff. And then the question is just going to be, well, who's getting the stuff, right? Who's actually going to inherit from you? In Texas, there are default provisions for this exact issue. I think I saw a stat one time that 75% of people don't have a will, and a will is a part of your estate plan. But overall and in general, an estate plan gives you the opportunity to designate who will get your stuff. And not only who will get your stuff, but who will be in charge of ensuring that your stuff goes to the right people. There's several jurisdictions around the world where you die and maybe the government takes everything, or they already have another form of how property passes in particular after death. In Texas, we have the freedom and the luxury to decide exactly where we want our stuff to go. I tell my clients all the time, it's your property. You get to decide what you want to do with your property. There is no right answer. A lot of people think it has to be split up maybe between the kids, or, let's say there's a kid that's out of the picture. And so, how do we deal with them? Suffice it to say, it's a plan that we can put in place for your property after you die. The question, of course, will just be, well, do you know when you're going to die? If you can tell me that date, you know exactly when you're going to die, then our plans can change. But generally speaking, estate planning, again, when we think about when are we going to die, what needs to happen to my stuff, if you're a parent of a young kid, what's going to happen to my kids, it changes with time, right? So as we go through our seasons of life, so right now, like I said, I'm a young dad. I got my wife and my 3 kids. I have a plan in place that makes sense for right now. That's what I call a young Texas family will. I have it in place. All the property is going to go into a trust for my kids. If my wife and I were to die together, that trust is going to be managed on behalf of my children until they turn 25. And then once they turn 25, then great. Then they get an outright distribution. We name what's called a guardian for those kids. And all that is a part of the estate plan, right? Again, I'm thinking about, okay, if I was to die tomorrow or next week or next month or next year, what needs to happen? What kind of plan do I have in place? As I get older, and as, again, the clients will get older as well, they'll come back to me and say, okay, well, now what do we need to do? It just changes with time. The general framework, though, for estate planning is a matter of either convenience or control. This is a spectrum here. So people that just want to make things as easy as possible for their family. Let's just say they want to make sure their house goes down to maybe their surviving spouse and then to their kids. Let's make sure their bank account gets to, again, the surviving spouse or their kids. There is a great way to do that, a great package that we can put together, make it as convenient and as easy as possible. A lot of cost savings, frankly, go into that because of how convenient it is. We put the whole plan together, sign all the documents, we'll give you counsel all the way through, and it makes it as convenient as possible. Unfortunately, what we've seen before too is that there might be fights that happen. There might be disagreements. I've seen this scenario a lot where the house basically gets passed down to, let's say, brother and sister, or it's three sisters or any number of siblings there, and all of a sudden they can't decide what to do with the property. So yes, it was very convenient, very, very convenient in the sense that the property got down to where it needed to go, but all of a sudden the kids are fighting and they don't know what to do with the property. There's no one in charge, and so there's no hierarchy, there's no structure, and that's where we get over to this control aspect. So people that really want to make sure that their property is controlled after death, right? Estate planning. Again, we're thinking about, we're going to die, it's going to happen, what needs to happen to our stuff. That's where this control aspect comes in. So you might have heard about a trust before. Do you need a trust? Does a trust make sense? What is probate? How does probate factor in all this? We'll get there in just a second. With regards to control, though, know that it still comes down to an estate plan, right? It's how do you plan for these things to happen? How do you plan for your property to get in the hands of, again, whoever it needs to be? Who needs to be in control and who needs to receive the property? So a lot of times we'll talk through that. So, this is a great graphic. I wish I could say I designed this. Maybe it is something where the son needs to get the house. I'm going to change color here. Maybe the son needs to get the house and the daughter has some money. I've had that happen several times as well because I counsel people through. If we just split everything 50-50, it's really hard to split real property. So maybe there needs to be compensation for, okay, if one kid's getting property or another kid's getting heirlooms, another kid's getting money, how do we balance it out? It all comes down to the plan, and it's a matter of how much control do you want to exert. Okay, what's on my next slide here? Excellent. So this is a great representation as well. This graphic here says testament, last will, and testament. And maybe you've heard of that before. That is really the foundational document for an estate plan. A will specifies in a legal way who needs to be in charge of your estate, what your property basically that's compiled after your death, and then where does your property need to go. We can specify all sorts of other things depending on your unique situation. For example, if you anticipate someone challenging your will, we can put guardrails in there and protections in there. If you got young kids, we can put in what's called contingent trust. We're contingent on the fact that you and your spouse might die together, so then what needs to happen to your kids. All sorts of things we can put into that will, but the will sits as a foundation for the estate plan. It's the legal document, and there's laws in place in Texas of how it has to be executed. You got to have two witnesses in the presence of the testator, that's you signing the will. And then usually we always want to have what's called a self-proving affidavit, a way to prove up that you in fact signed the will, the witnesses watched you sign the will, and then the notary can of course take the affidavit and notarize that document. And the whole idea there is kind of the same thing, that hey, you made a plan, so you know exactly where maybe your house is going to go, where your money is going to go. And so when that plan's in place, and we can again make it more control, we can throw in all sorts of other strategies in place. But once we have that plan in place, then we're in a really good position to make sure that your kids or your loved ones are taken care of. Okay, so these are some of the basic documents in an estate plan. I think this is worth going over just touch by touch, document by document to see which one does what. Starting with the will, we just talked about that. The will is that foundational document. Highly recommend if we do the convenience plan, what I call the Texas family plan or the young Texas family plan. It all starts with the will, and depending on your situation, the will would mainly serve as a backup plan. Now, why do I say it's a backup plan? Because there's other legal documents that we can use in your estate plan to ensure that your property goes to where it needs to go without having to what's called probate the will. Now, probating means we have to go to court. We take that will, that legal document that was properly drafted, it's well written, it's properly signed by not only you, but the witnesses as well. We got a notary that signed it off. Okay, now you have passed away. Your family's coming to talk to me again. What do we need to do? Well, it depends on how we set up your estate plan. Did you want to avoid probate and avoid any kind of government intrusion or any kind of tax issue? Or did you just kind of say, I want to make this as convenient as possible for me and pass everything on my kids, they can figure it out. If that's the case, that might not be an issue at all. You might have kids that get along perfectly fine, but the will just serves as a backup plan because we're not having to probate it depending on several different factors. A trust comes into place because the idea here is that you're basically creating a structure to put all your property in. So it's no longer so much in your name. It's not in your individual name, but it's now in this entity, basically a relationship, but it's a separate relationship from this you as an individual. That trust can then hold the property. That could be your house. It could be your retirement accounts, your bank accounts, personal property, all sorts of things we can put in the trust. And the idea there would be that if you don't have any property at the time of your death, there shouldn't be any need to probate the will. Now, let me just put a quick caveat here. I've seen plenty of instances where some perhaps well-meaning attorney has recommended trust, what we usually call revocable living trust or family trust, to people. They have a binder that's about yay thick, and it does just about nothing. It doesn't have properly funded documents. It doesn't have conveyance documents. In other words, not all the property made it inside the trust. And so it looks really nice and pretty and official and makes you feel good for, paying thousands of dollars for the thing. But ultimately, we could have avoided probate, and we could have set aside your estate plan in a much more convenient fashion, in my humble opinion, much more cost-effective fashion. Trusts do come into play for a lot of different scenarios. So I mentioned the young families. If you get the Young Texas Family Plan, that's where we set up contingent trust. And really, they're legally called a testamentary contingent trust, which just means we put the trust in the will. And so we don't establish the trust yet because we're really not planning for you to die, right? We're going to plan for the young people to keep living, grow up the kids, get them out of the house, and then come back and see me. Let's talk about a new estate plan. That trust, though, is really good because we can't just hand over property to kids, right? We can't just say, hey, Topher, I know you're only, 5 or 6 or 7, however old it might be, and, Lord willing, it never happens. But we can't just hand the keys to him and say, good luck, figure it out. Pay the mortgage on time and take care of the water bill and, oh, yeah, looked after your brother and sister there. Can't do that. They're just kids. So what we do is we set up guardianship provisions. So we name someone that's going to take care of the actual kids. And then we set up a trust. And so then all the property that I would have at that time would be pushed out of my estate into that trust, probably liquidated, which just means we sell it for money, put all that money in a trust account. It's managed by someone. And then, Lord willing, it grows. And over time, that pile of money grows. But then distributions can still be made to those kids. So their clothing can be paid for, their food can be paid for, their school can be paid for. All that stuff is taken care of out of the trust. You might have a situation where you have a special needs child, whether a minor or an adult child. We set these up as well. They're called a special needs trust. The idea there is that we probably don't want to just give an outright distribution to your special needs child and run afoul of the Social Security threshold. And so we'd put their share in a trust, and the trustee would be instructed to only give out of that trust a certain limit so as to not run afoul of the Social Security or any other benefits that he or she might receive. Trusts are also very, very good when we do anticipate family fights. And when we do anticipate, fortunately, sometimes death and money bring out the worst in us. So if we're anticipating a fight, then usually that's what I recommend to my clients is saying, okay, if we have a sizable estate, maybe we're thinking about at least $1 million, if not more, then maybe what we want to do is put that aside, have a professional manage that, a professional trustee. And so your kids can still inherit and still benefit, but then we're not worried about the kids fighting with each other. We're not worried about one kid being in charge and having to make certain decisions for their siblings. We just say, you know what, there is a inheritance, a really nice inheritance here. Let's just put that all in the trust and we can let that grow. And so then the estate plan will just look, we're still taking care of the kids, but we have, again, just more control over that. 2 other documents, really 3 other documents here. Power of attorney is there's 2 different kinds in Texas. There's what's called a medical power of attorney, and then sometimes referred to as a durable power of attorney, or some people call it a financial power of attorney. Basically, those 2 documents, one, the medical, is in the event that you are unable to make medical decisions, you're incapacitated in some way, then you can name someone to be in charge of your medical decisions. Usually that's the spouses are naming each other. If we're in a widower situation, then that's usually the kid who's closest that's taking you to doctor's appointments or things like that. The durable power of attorney or the financial power of attorney is really all your day-to-day things, right? So you have, maybe you need to sign contracts or other legal documents. Maybe you need someone to talk to the bank on your behalf, negotiate on your behalf. It could be, I mean, they're fairly broad powers there that you can give to someone. I generally say that you're probably maybe using 20% of the powers allocated, but the idea is that we don't want to miss anything and be in a situation where all of a sudden you're unable to make your decisions, but then the person you named, again, most likely either your spouse or an adult child, can't make those decisions either because they don't have the legal power to do so in that document. So we just make it fairly broad. That comes to us from Texas law, where those powers come from anyway. And so it's just a really good part of your estate plan, right? You're thinking about end of life care. You're thinking about what's going to happen to my property after I die. But we're also thinking about, okay, we're leading up to death too. And unfortunately, with the way we are in this world, as we get older, our bodies start to fail us more and more and more. And so that includes our mental capacity, that includes our physical capacity. And so that's what that power of attorney is for. We also have this directive to physician. So this is the idea that you're really thinking about end-of-life care in a terminal condition. Some people refer to it as pulling the plug. If you're in a situation where you're going to have to be on life support and there's no hope of coming back, the doctor says you're going to die within 6 months. It's a terminal condition. It's an irreversible condition. You can direct your physician to keep you as comfortable as possible and withhold life support. I would say 99% of my clients elect for this. They just either have seen it with their own parents, they've seen it in a different situation, how heartbreaking it is to be in that basically a vegetative state. And so they want to take it upon themselves to ensure that their desires and their wishes are legally acknowledged, and that's through this directive to physicians. So altogether, you can see, I think my next slide here, you can check out TexasFamilyWills.com. That's where we put basically our estate planning packages. We just try to keep it at a very flat fee for very specific situations. So again, if you're thinking about convenience or control, we have plans for you. We have plans for young families. We have plans for what I'd call basically just middle-age families, and then kind of our end-of-life care families as well. Frankly, it depends on what kind of assets you have as well. And so if there are significant assets, then we really do want to take the time to think through that. Part of the thinking through that is I would team up with your financial planner and your CPA and make sure that, hey, we're all on the same page. We know how this needs to go. We won't necessarily know the tax answers, and so that's where I would rely on your CPA, and your CPA won't necessarily know the legal answers. That's why he or she will rely on me, and then we both won't necessarily know the best strategy as far as your financial planning. And so we also want to bring that financial planner on board as well. So we have those plans available. Check out TexasFamilyWills.com. If this video was useful in any way, if this answered any questions, leave a comment or share it with your friends. I think there's just so much misinformation that is shared, and I think a lot of people have, again, that general anxiety about death, but then also just really worry about government and taxes and fighting and all sorts of things. And really, ultimately, the state plan should provide peace of mind. It should give you that peace of mind that I think a lot of people are after. And ultimately, that's what we do here at the Watson Law Firm, is we want to provide that peace of mind for that plan that you're after. So if we can help in any way, let us know. Share this. And if you need to get in contact with us, you can check out TexasFamilyWills.com. Thank you.